All right, let's take it up. This will be the State of Tennessee versus Heather Marie Tearson, and it is two cases, 2024 CR 66, and then also 2025 CR 34.
And then she has subsequently had charges that have been bound over, which are 2025 CR 34. We would enter a plea of not guilty. I mean, effectively, we're arraigning her on those charges and enter a plea of not guilty, and we've been provided a copy of it. But now we have a universal settlement on both 2024 CR 66 and 2025 CR 34, if the court would allow.
All right.
Your Honor, what we have worked out with the state is that on the first charge on 2024 CR 66, the charge will be amended to attempted child abuse and neglect. She'll be sentenced to 2 years in the TDOC as a range 1 offender. The 2 years will be suspended and she will be placed on supervised probation. Pursuant to the term and condition of the plea, she is to take an A&D assessment, but Your Honor, she's already completed that through juvenile court and she's done that. And she is to follow the recommendations / treatment program that is set forth, and she is doing that through the juvenile court. There's going to be 0 tolerance on drug use, and she will be required at a minimum to take monthly drug screens. As a term and condition of her probation, she'll pay the cost and she'll comply with all orders of the juvenile court for Dixon County. And again, Your Honor, on 2025 CR 34, she'll be pleading to count 1 of that indictment, which is simple possession of methamphetamines. She'll get 1129 suspended to supervised probation, $750 fine plus court costs. And it is concurrent with 2024 CR 66. Counts 2, 3, and 4 will be nollied by the state. And again, General, was I correct in my recitation? Thank you.
All right.
And so I have filled out the plea sheets. Mrs. Tearson has signed those. I haven't passed them to the DA yet, so. Those are plea sheets. I hadn't passed them to you yet. I was just going. So, Your Honor, we all have executed the plea sheets that we would request Your Honor approve.
Thank you. All right, Ms. Tearson, if you'll raise your right hand, Tearson, if you'll raise your right hand, let's place you under oath. Thank you. If you'll step in front of that microphone, please. State your full name for the record.
Heather Marie Tearson.
Ms. Tearson, you're here today on a 2 different indictments, and you've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of those charges? Talked them over with Ms. Roberts and you, and she discussed the range of punishment you're facing, the possible evidence the state might have, and any possible defenses you might have to that evidence.
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty according to the agreement that was announced in one case and nolo contendere, or no contest, to the other charge. I want to explain to you the difference. In the case of attempted child abuse and neglect, you're going to be pleading guilty. That means that you could be asked questions about that particular case. In the other case, you're pleading no contest or nolo contendere. What that means is you're not admitting you did anything on that particular case, but you're not going to contest the state's evidence when they give me their evidence, and that evidence will be used by me to find you guilty according to this agreement. Do you understand that?
Yes.
You understand, however, that you would have the right to plead not guilty on all charges and have a speedy and public trial by jury.
Yes.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford one of your own. You understand that at trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena? Do you understand that if you went to trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial? Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed and have a lawyer appointed if necessary to help you with that appeal? You need to speak up a little bit because
Yes.
we're recording all
Sorry.
of this. You understand that by entering this plea of guilty and this plea of nolo contendere, you are waiving your right to a trial on all of these charges and also to the appeal that might follow.
Yes.
Do you understand this is going to result in 2 different convictions, and those convictions are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime? You understand all the rights that I've explained to you? Do you understand that if you plead guilty on the one case, as I explained, state could ask you questions, state or the court could ask you questions about that offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we discover that you are lying under oath.
Yes.
Is your decision to plead guilty and no contest today voluntary? All right.
Not voluntary.
No, it's voluntary. Sorry, I thought you said involuntary.
That's the reason I asked the second question. Is anybody forcing you to do this against your will?
No.
All right. You understand that I have to have facts to support a finding of guilt in this case. All right, then, since we have a nolo contendere, it'd be easier if the state just gives me their factual basis.
That's fine, Your Honor. Can you hear me from here?
Yes.
Okay. In case number 2024 CR 66, on November the 10th, 2023, between that date and December 11th, 2023, Ms. Tearson has a minor child, approximately at that point in time, 2 years old. There was an investigation that involved a traffic stop over in Humphreys County in which Ms. Tearson was found in possession of drugs. She later pled to those charges in Humphreys County. Through that investigation, there was a DCS investigation as well that then came back to Dixon County where Ms. Tearson resides. And during that time period, Ms. Tearson, as well as her minor child, tested positive for illegal narcotics. The child tested positive for methamphetamine, cocaine, and THC. And that would be the basis of the child abuse neglect. In regards to the simple possession of methamphetamine, on September the 6th of 2024, there was a traffic stop of Ms. Tearson due to a violation in which she pulled out in front of a ambulance that was had lights on. During that time, there was a strong odor of marijuana coming from her vehicle, and she admitted that she had a marijuana roach in the vehicle. A subsequent search took place of her vehicle, and there was a personal use amount of methamphetamine found in the vehicle.
All right, I'm not asking that you agree with all those facts, but you understand that's what the state's evidence would be if this case went to trial, if these 2 cases went to trial.
Yes, Your Honor, and if I could, just from a standpoint to clarify in the record too, is that in the juvenile court, what the general said up to the point is correct, but then there was a subsequent hair follicle test. The positive test for my client was a urinalysis. There was a subsequent hair follicle test that came back negative. Immediately upon it happening, but from a best interest determination, Mrs. Tearson is the only person who has custodial rights to the child, and the biological father of the child, she allowed that person to have exposure to the child, or to have the child. And so again, the child was exposed. The child did test positive while she had the care and custody of the child. And so from a standpoint of a best interest determination, even though her hair follicle test was a negative test, she was the only person in care and control of this child when the child was exposed.
So are we saying that the child, I know you represented her in juvenile court, did it come out in juvenile court that the child was exposed perhaps when the biological father was around? Is that what we think
The
happened?
juvenile court, the child was removed from her in juvenile court and when we got the hair follicle test, the child was restored to her because the court determined, but she had gone through the whole process of doing all of DCS's requirements. And the child had been returned to her, and then the Department of Children's Services attorney, without knowledge and information to us, appeared and did a presentment to the grand jury on this case. And then she was subsequently arrested based on that. And so it was a situation where I felt necessary to.
So the urinalysis initially was positive, but the hair follicle taken right afterwards was negative on her. But there's no question the child was exposed.
Right.
And that your client's position that it was exposed was she was the primary caregiver for the child, but exposed by the biological father.
And and it was a failure to protect on her part.
Well,
It-
and
That's,
the only thing I would say to Ms. Tearson is you understand how this all kind of boomerang back on you, and that might tell you what you need to do about allowing this other individual to be around your child if he's going to expose the child. I'm not saying that that is what happened. I know the state may have a different version, but
and
this
then
is-
she subsequently got arrested for additional, so the drug issue is there.
Right.
So, again,
I was going to add, in addition to after she was charged with the simple possession of meth, there was another hair follicle, Ms. Turgeson, that came back positive.
Okay.
yeah, it was at the time, with the child scenario, it was a negative, but after that, this is a best interest determination, in my estimation, in my.
You have a
advice.
choice to make. If you want to do drugs, that's fine. I mean, nobody's going to stop you from doing that unless you get arrested. But if you do drugs, you're going to lose your child or you're going to kill your child. It's just that simple. So if you want your child to grow and be healthy and so forth, and I'm sure Ms. Roberts has preached to you about this as well, but you have that choice to make. You choose drugs or you choose your child. And hopefully you've learned a lesson from this and taken responsibility for it. And as a result of that, you will, move forward and avoid putting this child in that position. Are you satisfied with your attorney services? You believe Ms. Roberts has done a good job of representing you competently. Ms. Roberts, do you know of any reason that she should not enter these pleas?
No, Your Honor, I do not.
Anything further from the state?
No, Your Honor.
Then Heather Marie Tearson and docket number 2024 CR 66, upon your plea of guilty to count 1 and amended to an attempted child abuse or neglect, you're found guilty, sentenced to 2 years. Tennessee Department of Corrections has arranged 1 offender and will be suspended to probation. You're ordered to, as a condition of your probation, to undergo an alcohol and drug assessment and follow the treatment recommendations. There will be a 0 tolerance for any positive drug screens. That means you test positive 1 time, you will go to prison for 2 years. Somebody else will be raising your child. You understand that? You will be undergoing monthly drug screens as a condition of your probation. You're ordered to pay the court cost and comply with the juvenile court order that's entered in your child's case. In docket number 2025 CR 34, upon your plea of no contest to simple possession of methamphetamines, you're found guilty, sentenced to 11 months and 29 days in the county jail, suspended to supervised probation, $750 fine plus costs. That will be served concurrent with the prior case, and counts 2, 3, and 4 are dismissed as a part of the agreement. She'll need to see probation.
Thank you, Your Honor.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials